Every year in Georgia, there are approximately 130,000 car wrecks on our highways, and I hope and pray this does not happen to you or to a family member. But if it does, will you know how to take on the insurance company and their lawyers? Will you know your rights? Will you know the insurance company's responsibilities? Well, no one should have to take on the insurance company by themselves. I don't think it's a good idea. When I started practicing law, I used to defend insurance companies and the people that are out there causing the wrecks. But now I only work for injured victims and their families. So let's talk about personal injury law, and let me tell you about the three things that we have to prove in these claims. All right, number one, we have to prove that someone was negligent in causing the wreck besides our client. Number two, this person's negligence was the proximate cause of our client's injuries. And number three, we have to prove the damages that our client sustained in the wreck. I know this sounds somewhat complicated, so let's break down each one of these three elements for you. Negligence. This essentially means who's at fault in causing the wreck. We have to prove that someone besides yourself was at fault for causing the wreck. The injured party always has the burden of proof in showing that the defendant driver was negligent in causing the wreck. For example, when the defendant rear-ends your car because they did not maintain a safe following distance or they failed to keep a proper lookout of the road ahead, they were negligent. When the defendant rear-ends your car because he didn't get his brakes repaired even though he knew they were not working properly, well, he's negligent. Other examples could include following too closely, driver distractions due to using a cell phone or trying to adjust the radio, speeding or traveling too fast for conditions, tailgating, driving under the influence of alcohol or some illegal drug, failure to yield while turning left, and perhaps driver fatigue. Number two, proximate cause. Once we prove that the other driver was negligent, then we must show that the negligence of that driver was the proximate cause of your injuries. Okay, here's an example. You are at a complete stop at a red light. The defendant is not paying attention to the road ahead and crashes into the rear of your car. Your head hits the steering wheel and it causes a huge cut on your chin and you chip a couple of your teeth. Well, the defendant's negligence was the proximate cause of the wreck as well as your injuries. All right, damages. This is the third thing we have to prove. When we prove that the defendant was negligent and his negligence was the proximate cause of the wreck, we now must prove what damages you sustained because of the collision. Damages could include compensation for your medical bills, and that can include your ambulance bill, the emergency room physician, the radiology, which would be the x-ray cost, medical doctors, any other specialists that saw you at the emergency room, follow-up treatment, including chiropractors or physical therapy, any prescriptions that are written to you because of your wreck. And this is easy to prove because all these healthcare providers, all these suppliers will issue an itemized statement or bill for the services that they provided to our clients. Here's another element of damages, lost wages. Typically, if someone misses time from work due to a car wreck, it can be proven with a couple of check stubs showing that they missed time from work. And we would need a doctor's disability slip as well as a wage verification signed by your employer. Future medical expenses. Now, no one has a crystal ball that can tell you everything the future is going to hold for you medically. However, doctors can sometimes tell us to a reasonable degree of medical certainty what they anticipate you will incur should you eventually need a surgery or have to undergo some additional test or treatment down the road. All right, future lost wages. The way a jury measures future lost income is for them to determine what you would have earned in your job or your profession but for the injury. The future lost earnings can't be speculative, and you must have documentation to substantiate your claims. Punitive damages. Now, this is a huge element. Sometimes the defendant's conduct in causing the wreck or his actions immediately after the wreck are so egregious that the law allows us to seek additional damages known as punitive damages. The purpose of punitive damages is to punish, to penalize, and to deter the defendant from repeating the conduct. General damages are designed to compensate an injured victim for losses such as pain and suffering, emotional suffering, hardship, or inconvenience. There's an old saying that the easiest pain to bear is someone else's. Well, there's a lot of truth to this statement. It's a challenge to get a jury to understand the degree of pain and suffering that someone experiences because of a wreck, especially when the injuries are not visible. And this is clearly one of the areas where an experienced personal injury attorney can help argue the specifics of your case to the insurance company. Now, this is so important. If you have questions about your potential claim, please give me a call. You have absolutely nothing to lose by calling me, but think of all you can lose if you don't. Just pick up the phone. Pick it up right now and give us a call at 1-800-WIN-WIN-1. The consultation is free. It is completely confidential, and there is no obligation. You can also visit our website. It is loaded with all kinds of information about personal injury claims here in Georgia, and you can learn a lot more about me and about my law firm. Again, the phone number, 1-800-WIN-WIN-1. You've got one chance, one shot at justice to get all the cash and benefits that you deserve.